For months, bar advocates have been demanding better pay, but they have stopped taking on new cases as a way to protest. Well, now those case dismissals, they're piling up, and that's creating other problems.
You represent the district attorney.
Yep, yes, Your Honor.
How does public safety figure into all this? Are we gambling with public safety?
It is a mess, Your Honor.
And we're back, y'all. Thank you for watching today. Go ahead and hit that like button, my people. You know that it helps us out a ton. And of course, it helps you because it helps us keep bringing you these stories every day. Now, y'all, today we're going to talk about your girl. That is Michelle Wu. And not only Boston, y'all, but the whole state of Massachusetts right now is in a bit of a crisis. Now, this is something you won't see on CNN. This is something you won't see. They won't even talk about this on MSNBC. But I've been talking to you about this since the summer. This is the 4th or 5th video that I'm making about this topic. And I'm going to follow it all the way until the end, y'all. This is so serious that in today's video, you're going to see the Supreme Court of the state of Massachusetts, the highest court, is taking a look at a simple question. The question is about attorney pay. See, the public defenders, y'all, the people whose job it is to defend those who are accused of crimes, people who cannot afford their own, you've heard that on the movies, if you cannot afford an attorney, one will be provided to you. That's a constitutional right. If you can't afford an attorney and the state won't provide you one, they gotta let you go. Like, they have to free you. Okay. And in Massachusetts, they have something called the Lavallee Protocol that I'm going to explain to you here shortly. And they've been letting people go, y'all, hundreds and hundreds of people. On my last thumbnail, I said 2,000 criminals released. Okay, so this is no small deal. Well, now this is in the Massachusetts Supreme Court. You're going to see a little bit of the arguments on both sides. It's very interesting stuff. And then you're also going to see at the same time that Massachusetts can't pay their attorneys. We can't pay you. We don't have the money. They do have the money to pay for other things. I'm going to let you guess what that might be. So y'all, without more lead in, let's just go ahead and hop into it. But before we do, y'all, we are launching our official Patreon. So if you want to be a founding member on our Patreon, we have just 222 slots, y'all. If you want to be a founding member, go down, click the very first link in the description, and you're going to feel good about this, y'all, because believe it or not, we are an actual paralegal school, and we help people get their paralegal certificate and get working in the paralegal field. And all of the proceeds from our Patreon, when you enroll as a founding member, all of that is going to go to scholarships for people who would like to study at our institute, y'all. So click that first link down in the description. Join us as a founding member, y'all. This deal will not come back. Now let's get into the story.
For months, bar advocates have been demanding better pay. It's a story that we've been following from the very beginning, but they have stopped taking on new cases as a way to protest. Well, now those case dismissals, they're piling up, and that's creating other problems. NBC 10 political reporter Matt Pritchard is on it for us. He has more from Newton District Court.
Well, you might remember that Beacon Hill lawmakers did pass a raise for bar advocates over the summer, but many of them panned that as a slap in the face, and as a result, the problem hasn't gone away. Solutions championed over the summer.
We feel that we've landed on a number that is significant.
Falling flat in the months that have followed.
It has not solved the problem.
You must increase the rate.
Some bar advocates still refusing to take on new cases, with trial court data showing 630 cases dismissed in Boston Municipal Court and 923 in District Court under the Lavallee Protocol as of October 21st. State lawmakers had hoped a $20 per hour pay increase over 2 years would be enough.
Cases have been dismissed. They've been refiled after the 45 days, and now they're up for being dismissed again.
Legislators are now being asked whether it's time to take another look.
We're always open and ready to revisit anything, but we think that we provided a very responsible, significant increase.
Do you think we need to revisit this?
We do. It's a situation that's clearly been mishandled.
Now, there's already movement. The Committee for Public Counsel Services has put an incentive program in place, paying advocates $2,500 in addition to their hourly rate to take on 5 backlogged cases, with a max of $7,500 for 15 cases.
Smoke and mirrors is a Band-Aid. What happens on January 1st? people still are not going to be taking duty days after January 1st.
And meanwhile, the Supreme Judicial Court is set to review the rate issue at a hearing on November 5th.
I guess they're going to leave it up to the Supreme Judicial Court to decide this issue, and no one knows how that's going to end up.
Now, I've been told that some bar advocates have had to go back to work because of various financial pressures, but the result of that is many of them are taking on massive caseloads, 10 or more, in a single day's work. In Newton, Matt Pritchard, NBC 10 Boston.
All right, so let me just go ahead and prime you with a quick story about what Massachusetts does have money for. And then we're going to get into these oral arguments in front of the Supreme Court. And I'm going to tell you, these women are sharp, y'all. I would not want to have to go up against any of these dynamite attorneys, y'all. These women are on point. But first, let's just take a look at what Massachusetts seems to have plenty of money for somehow. Take a look at this.
The Massachusetts GOP is criticizing Governor Maura Healey over a new report that shows shifting shelter costs to the state's home-based program. The program provides rental assistance to migrant families. According to the report, Massachusetts is on pace to spend $97 million on the home-based program in the current fiscal year. The state spent approximately $9.5 million on housing at-risk families. Massachusetts Republican Party Chair Amy Carnevale released a statement following the release of the report, saying in part, quote, "As much as Maura Healey would like the public to think that she's improving the system, the data tells a different story."
All right, so they do have money for that, okay? At least, so if you want to go out and then come back in, you want to go out and come back in, you want somewhere to stay, you want some free stuff, you're going to be taken care of. But if Massachusetts wants to accuse you of a crime and they want to put you on trial and you're like, hey, I didn't do anything, but I don't have money for a lawyer. Doesn't the Constitution say you're supposed to provide me with one? They're going to say to you, we don't have money for that. That's something we don't have money for. Now, y'all, one quick thing. You're going to be hearing about the Lavallee Protocol. You need to know what that is. It's very easy to understand. It's from 2004. It's a rule in Massachusetts. It says if you stay in jail without an attorney, you must be released after 7 days. And if you remain out on bail without an attorney, your case must be dismissed after 45 days. So in other words, if you can't afford an attorney and you're in jail and the state can't give you one, after a week, they have to let you go. After 45 days, they have to drop your case altogether. They have to dismiss your case. Okay, 7 days in jail, they can't help you. You get free. 45 days, they have to drop the case. All right. Now watch. Okay, so the first person we're going to hear is representing the attorneys who's saying, look, you got to pay us what we're worth. Like, we can't work for substandard wages. Isn't Massachusetts one of these like pseudo-socialistic type of societies where everybody's supposed to be taken care of? So they aren't taking care of the attorneys that are providing the constitutional rights to the accused criminals? Let's take a look at what she has to say.
Good morning, Your Honors. Rebecca Jacobstein from CPCS on behalf of the unrepresented defendants in Middlesex and Suffolk counties. I wanted to start by addressing the two questions before the court today. First, in light of the present shortage of counsel, which has resulted in the ongoing systemic denial of constitutional rights of indigent defendants, do the courts have the authority to order increased compensation? And the second question, if so, under what circumstances? The answer to the first question is a resounding yes. The courts are the ultimate protectors of constitutional rights. They must protect the right to counsel, they must protect the right to a fair trial, and they protect the right to access justice. And they cannot protect the right to access justice or the right to a fair trial without an attorney guiding a person from the beginning.
And isn't that why we have the Lavallee Protocol?
Yes, but the Lavallee Protocol is a temporary remedy. It has been 5 months. I got updated numbers as of yesterday afternoon. We still have over 900 people without lawyers. And this is like, as in Lavallee, the court implemented the protocol even though there were actions taken to possibly resolve the problem. But they still acted because there was no assurance that those people would solve the problem. We can now be assured that right now, legislative action, which has improved the problem, has definitely not solved.
There are a bunch of defendants whose cases have been dismissed without prejudice. Those defendants are not currently facing criminal charges.
Those whose cases have not come back, correct?
Right. And so it appears that, as you say, this has gone on for a really long time. So more and more defendants' cases are being dismissed. So
yes,
you say that Lavallee was only intended to be temporary. What is the difference between 155 defendants getting the benefit of the Lavallee Protocol for a shorter period of time and 2,000 defendants getting the benefit of the Lavallee Protocol over a longer period of time? What's the constitutional difference there?
Because at this point, we are now baking into the system the denial of the right to counsel, right?
All right. Pretty compelling argument. So that's the plaintiff, y'all. That's the people who are moving. That's the people who are, let's say, suing. These are the attorneys who represent these indigent defendants, and they're like, you have to pay us what we're worth, or we just aren't going to take the job. I mean, simple as that, right? So that's the movers. Those are the plaintiffs. Now the defendant. This is the Attorney General's office for the state of Massachusetts. They're basically going to say, don't make us pay them what they're worth. Don't make a look what they're worth. That's my term. So I should use a less biased term. Don't make us pay them what they say they're worth. That's a better way of because I don't want to be biased in this. We're going to pay them what we pay them. The legislature decides the pay rate, not the Supreme Court. It's not your job. It's not my job. It's the legislature's job to decide pay rates.
You had to talk to the private bar, and we've done everything humanly possible on our end. We still can't go here. It's a categorical violation of Article 30.
Your Honor, the position of the courts is not categorically that the court can do nothing.
No,
it is that categorically the courts may.
More Justice Wolhojan's last question. I see why we shouldn't be crossing the line if there's still things for us to do. But if we've exhausted everything possible, don't we have the power then to cross the line, or no?
Your Honor, the position of the courts would be that there should be no circumstances where the courts cross one particular line, and that line is judicial rate setting. In this particular case, there are no circumstances where the courts should do that for at least two reasons. First, as Your Honors have already stated, it would be plainly inconsistent with the core power of the legislature, that being evaluating the many competing policy interests and financial interests that underlie each and every legislative decision, particularly given the inherent limits placed on state funds. The second reason, Your Honor, is that there is great benefit to this court providing clarity for bar advocates and for all other stakeholders that the role of the courts is not to set attorney compensation rates.
But we've done it. I mean, there are a slew of cases where the court has both assigned defense counsel and ordered the payment of the rate that the court determined was reasonable to that counsel.
Your Honor, first, with respect to cases where that happened in the past, all of those cases took place prior to the system that has been established with the creation of CPCS.
And so you think that the creation of CPCS has ceded this inherent authority of the courts, even when that system does not result in the protection of the constitutional rights of the defendant. That somehow, by creating CPCS, the legislature has stripped the courts of the inherent authority they had prior to CPCS's creation.
Your Honor, in each of, as Your Honor correctly points out, in each of the cases that existed prior to the creation of CPCS, judicial decisions with respect to what might be an appropriate rate of compensation for attorneys were not inconsistent with any existing statute.
And now a local district attorney's office is on the side of the Attorney General's office, who's also saying, look, the legislature decides the pay rates, not the Supreme Court. So the Supreme Court is trying to decide, like, is this even our job to be deciding pay rates? Or that's what they're trying to decide. But notice how this representative, this lawyer for Suffolk County DA's office, notice how she says, she admits this is a crisis. This is chaos. The situation, the way it is loco.
Because of the nature of the shortage. And I want to go back to Justice George's question.
So you don't think that part of the solution would be to tinker with the Lavallee Protocol itself?
Possibly.
Okay, so those would be something like
shortening the amount of time that people can be held in detention, or dismissal with prejudice as opposed to dismissal without prejudice, correct? Are there any other components of the Lavallee Protocol that could be considered?
I think those will have to be played out in the single justice session and eventually make their way up here. As for today, I'm not sure, and certainly from a public safety perspective, I don't think any of those are appropriate measures.
But there would be no Article 30 concern.
No.
Right?
No. Yes, Your Honor. And going back to Justice George's question.
I think you're going to read my mind, because I read that same case in the ACLU case.
Yes.
And that's why I started with this.
Yes, Your Honor.
There, in those contexts, that there was an organic contextual problem.
Yes, Your Honor.
It wasn't one that seemed to be, I don't like the rates that I signed up for, so I'm not going to take cases anymore, which to me suggests something, a different analysis. So please.
Yes, Your Honor, thank you. And I would point out that the record here does bear out that the shortage here is a concerted withdrawal of services in the busiest counties in the Commonwealth for the purpose of forcing the legislature to raise rates. That was the stated purpose by bar advocates in withdrawing their services and providing indigent defense in the busiest counties in the Commonwealth, knowing that the protocol would go into effect and that chaos would result. It has resulted, and their stated purpose has been met. The legislature responded. Now it's this court's job to say Article 30 prevents us from stepping in. We need to see how this is going to play out.
You represent the district attorney.
Yep, yes, Your Honor.
How does public safety figure into all this? Are we gambling with public safety?
It is a mess, Your Honor, in the trial courts.
So y'all, hope you got a lot out of that. You're looking at actual state Supreme Court oral arguments. You're looking at the court try to decide. The court is actually, with the help of the attorneys and the arguments and the case law, they're trying to decide, is it even within our purview to get involved in this? Like, the court might just say, hey, you know what, we heard the arguments, this isn't even our domain. In fact, that's what the defendants are trying to convince the court. Like, look, this isn't even on your plate. This is the legislature's job. You're the judicial branch. You don't even really have a say in this. So, we will be following the ruling from this, whether the court says, yeah, this is our domain, and then make some kind of ruling on pay, or whether they kick it to the legislature. Whatever happens, you already know. We will bring you the latest when it happens. But let me know. So we have two questions here. We already know that the legislature, the lawmakers, set the pay rates. So should the court get involved, right? Is that even their job? So let me know, do you think the court should get involved? I mean, people's rights are violated right now because they don't have the representation that they need, that they deserve, their constitutional right. But should the court get involved? That's one question. And two, what should they pay them? I think they're at $60 right now per hour. I think they want it like 80, something like that, y'all. They want their pay rate to become comparable to other states in the area, y'all. So let me know what you think about all this, y'all. Did you get something out of watching this? Hopefully you did. Drop a comment down below, y'all. Before you do, please stop, hit the share button. Y'all, let's get this video, let's get it out there to other people. They need to know what's happening in this country of ours. Share it over email, text message, WhatsApp, Facebook, Snapchat, Instagram, all of your favorite social mediums. And of course, if you're not a subscriber, please do subscribe. Y'all, check out our Patreon. We're trying to grow it up. We're trying to blow it up. It's the first link down in the description. Go over there, join. It's just $9 a month, and you are going to be supporting the education of someone who wants to enter the legal field. All of the proceeds are going to scholarships for people who want to study and enter the legal field. I want to thank y'all for watching. Love y'all, and we'll see you back in the next one.